wasn't CJ Corona in the stand, tatanggapin ba natin yung sagot na yon? O sasabihin natin, ano ba ang iyong ebidensya? Especially when the explanation is against human experience or normal human experience. Marami po na mga may edad na sa lipunan, nilalagay sa anak ang mga account nila. Pero tama po, bihira yung anak ang nilalagay sa kanilang magulang. Bakit ang isang clerk hindi lamang nagdeklara ng isang stall sa palengke, tinanggal na? Bakit ang mahirap pag nagnakaw, bawal? Ano ba sinasabi natin sa mahirap? Bawal magnakaw. Bakit sa mayaman, bawal magnakaw? Ng konti. Kasi pag nagnakaw ng marami, lahat na ng technicalities, lahat na ng batas, lahat na ng pwedeng ikomplika ang sistema para protektahan siya ay nasa kanya. Bakit po pag mahirap na huli ang sasabihin sa kanya, sa presinto ka na magpaliwanag? Bakit po pag mayaman, lahat ng lusot, batas, technicalities available sa kanya? Sa totoo lang po, sobra po ang ganda ng pagpapatakbo ng ating presiding officer ng korte na to. And I admire the prosecution and the defense, and I admire my colleagues. Pero let's be honest with each other, 44 days, more than 200 hours. Sa totoo lang po, isang linggo, kaya natin tapusin to. Kung nilagay na lang natin sa stand at nagsabihan na lang tayo ng totoo sa isa't isa. At tingin ko po, kung mahirap po ang akusado, nasa presinto, nagpapaliwanag na lang siya. Tingnan niyo po, kahit sa cellphone. Di ba pag mahirap, nahulihan ng asawa na may sweet na text sa iba? Ano sabihin niya? Honey, mis-sent po yan. Hindi ko sell yan. Pag mayaman, kukuha ka pa ng abogado? Sasabihin mo pa? Darling, hindi ko text yan. Hiniram ng iba yan. Nakikigamit lang ako ng cellphone o share kami in trust yan. Commingled ang mga text kaya hindi akin yan. Why do we complicate what is so simple? Technicalities which should protect the rights of people. And I don't blame this court for sticking to technicalities because this is supposed to protect the rights of people. Pero somehow in this country, it is being used to protect people who plunder this country. I remember my law professors at Ateneo School of Law. Sabi niya sa amin, and those of here who graduated from the same school would remember this. If you are strong on the facts, pound on the facts. If you are strong on the law, pound on the law. But if you are not strong or you are weak both on the facts and on the law, pound off the table. Pukpukin ang batas kung doon ka malakas. Pukpukin ang katotohanan o ang facts pag yun. Pero pag hindi, pukpukin mo na lang ang mesa. Yun po ang turo sa ating mga abogado. But can't we agree as a nation to pound on the truth, to pound on justice, and to pound on grafters in this country? Sabi po nung iba, mabait daw po si CJ Corona. Sabi nung iba, hindi siya notorious sa Supreme Court. Actually, kilala din po namin siya at mabigat po sa amin. Some describe him as decent. Kaya sabi po ng iba sa akin, mag-abstain ka na lang kasi komplikado naman ang batas, komplikado naman ito. This is my reply to them with all due respect. If your client cannot explain, I cannot abstain. If you did not disclose, we have to depose. And if you are not fit, you cannot sit as the CJ of our Supreme Court. You will have your day in court. You will have your day in media for civil case, for a criminal case. But for the impeachment case, ang pinag-uusapan po natin yung kabutihan ng ating bansa. The impeachment court does not simply pass judgment on this specific case or on this specific CJ. The court's action being far-reaching and precedent-setting is actually rebuilding a new paradigm of transparency and accountability in public office. The verdict of this court will affect 1.3 million or more than 1.3 million civil or public servants, government employees and officials. It will affect 100 million Filipinos here and abroad. It will affect our future because transparency and accountability fights corruption. And corruption has a direct correlation to investments, business, jobs, prices, and the quality of services we give our people. Ang korupsyon po, direkta ang epekto sa presyo, sa kawalan ng trabaho at sa kita ng bawat mamayan. I cannot agree with the CJ's interpretation of the law in his explanation that the 80 million pesos and $2.4 million. However, in signing the waiver that allowed the Ombudsman to look into bank accounts, he has set a new standard. Bagong pamantayan. Sabihin nyo man napilitan na siya, sabihin mo na lumabas, pumirma pa rin siya at sinubmit niya yung waiver. We should all follow this standard. Etong pamantayan na to ay dapat para sa atin lahat. Transparency of bank accounts is good. I asked the President to instruct his cabinet, sign the waivers or resign and leave government. Executive, Legislative, Judiciary, COA, COMELEC, BIR, Customs, Judges, Governors, Mayors, Barangay Captains, Congressmen, Senators, let us agree on one standard. At least, ito kung ginawa ni CJ ay maganda. We can agree on safeguards and protection. Hindi naman ibig sabihin na lahat na lang ikakalkalin ang bank accounts, di ba? Payagan natin ang ombudsman na kung may kaso o issue laban sa inyo, makita niya at tignan po ito. Hindi po pang-haras o pang-abuse to. But all of us should have the same standard. The waiver taken together with the SALN at kung may papasa natin ang Freedom of Information Law, we will have entered a dawn of transparency and accountability in our country. It will be a new milestone in the tuwid na daan. For myself, gagawin ko po ito. Pag ako inimbestigahan ng ombudsman, papayag po ako na buksan ang aking account. Okay po ako sa waiver. Wala dapat ikatatakot kung walang tinatago. Ayoko rin iharas, ayoko rin kulitin. Pero wala po tayong choice. Kung gusto natin magbagong bansa, dapat pare-pareho. Hindi ko makakalimutan ang pag-iyak ng aking ama nung gabing yon, hindi dahil sa sakit ng tiyan o dahil ang katawan niya unti-unti pong nadudurog na sa sakit, kung hindi dahil sa pagmamahal ng kanyang inang bayan, ang bansang Pilipinas. Nais ko po ng pagbabago. Nawa sa desisyon na ito, nakapag-ambag, nakatulong po ako ng konti. Masakit man ang proseso, sana nagdulot ito ng pagbabago sa ating bansa. Presume him guilty, presume him innocent, give him his day in court, ascribe to him good faith, yes, sa civil and criminal cases, sa media, etc. But not today and not in this impeachment court. Guilty with the penalty of removal from office.
Honorable Senator Judge Cayetano Pia.
Today, we face a difficult task of deciding whether the man who holds the highest position in the Supreme Court has committed acts tantamount to betrayal of public trust that would warrant the removal from office. It is all the more difficult for me because I took my oath before this man. If this were a purely legal process, my legal training would require that much of the evidence presented is disregarded due to irregularities in obtaining the same. But this is not a purely legal process. The framers of the Constitution did not set the quantum of evidence nor the burden of proof required to convict. Much was left to the individual conscience and the collective wisdom of the Senate. Further, impeachment cases are heard by senator judges with different professional backgrounds. Of the 23 senator judges, less than half of us are lawyers. Thus, I was challenged and admittedly burdened by the need to balance my legal training as a lawyer and my calling as a public servant, particularly a senator judge. The Chief Justice states that the requirement in the Constitution to declare one's assets, liabilities, and net worth is as may be required by law. He then cites Republic Act 6426 or the Foreign Currency Deposit Act as that law, which states that dollar deposits are absolutely confidential, thus providing him with a shield. Is that the law in point? Is that the law that the Constitution stated will be required by law? I submit it is not. It is Republic Act 6713, the Code of Conduct and Ethical Standards for Public Officials and Employees, which, among others, requires the submission of a statement of assets and liabilities and provides the details thereof. It requires stating all kinds of assets, including cash on hand and in banks. There are no exceptions. To allow the contrary view would be setting a deadly precedent. It would allow any official to hide his assets behind the cloak of the Foreign Currency Deposit Act. Does that make sense? It does not, both from a legal point of view and from a lay person's view. Bakit pwedeng itago ang pera sa dolyar? Makatarungan ba yun? Republic Act 6426 on the secrecy of foreign currency deposit is not an exception to the law requiring the declaration of the SALN. In fact, it is easy to reconcile the same. A government official should declare his assets and liabilities, but then no one can examine the bank account without his written consent. The defense then posits the view that misdeclaration in the SALN is minor and therefore not an impeachable offense compared to other impeachable offenses like bribery and treason. As a lawyer, to me, minor inaccuracies in the SALN, such as parking lots or a unit whose ownership is under contention, would not amount to betrayal of public trust. In fact, corrections are allowed under the law. But the failure to declare $2.4 million and some 80 million pesos is not minor. In decided cases, the Supreme Court has ordered the dismissal from service of public officials and employees for failure to declare a sari-sari store, 2 motor vehicles, and for non-declaration of several assets such as real property and bank deposits. These are the cases of Rabe versus Delsa Flores, Ombudsman versus Nieto, Racho Flores versus Montemayor. I also have difficulty accepting the defense of commingled funds. Yes, the fact of commingling of funds, I believe, is common among families. But the huge amounts involved leads much doubt in my mind. In our interpretation of the law, we who hold a position of public trust must choose the interpretation that will uphold public interest over private interest, regardless of whether malice or an intent to suppress the truth was present. We must remember that public office is a public trust. Once the trust is gone, we must step down to preserve the integrity of the position we hold. Pag nawala po ang tiwala ng taong bayan, dapat po bumaba na sa pwesto. Dapat po pangalagaan ang posisyon na yon. Lastly, we need to remember that we can only mature as a democracy if we can learn from this impeachment experience. From the start, I questioned breaches in procedural law and ethical conduct of various participants in the impeachment process. The trial by publicity, the irresponsible hurling of bloated, unverified figures and assets, among others. My fervent hope is in the future, the pursuit of justice will be conducted in a more responsible manner, lest our children are left with the impression that those accused of wrongdoing can be persecuted without respecting their rights. The other lesson must go beyond the Chief Justice. It is the call for transparency. I echo that call. Those of us who sit as judges, those of us who act as prosecutors, and all those in public service should not hide behind our titles. We must come clean and give meaning to the constitutional requirement that we declare